Another judge runs from the Sixth Amendment.
And it'll answer, well, close to 1,000 pages. It has those questions outlined in there. You're expected to know
Are
that.
those Michigan court rules, is that statutory law?
I'm not going to keep going back and forth with you, sir. All I'm going to do, lastly, she has a valid driver's license. All I'm going to do, lastly, is give you the dates.
Just keep in mind the driver's license, it is a contract. It is a contract. And if you have a driver's license and you have not qualified your signature on that driver's license, like for an example, putting TDC, which is threat, duress, coercion, or you can put V.C. which means V compulsivo, which means I'm being forced to do this, or something similar to that to qualify your signature. And remember, these things are put before you sign your name. Before you put your signature, you put these qualification statements before you sign your name. You do not put it above your name. You do not put it below your name. You do not put it after your name. You put it before your name. Your name is what they need. You need to qualify it before they get it. Don't give them your signature and then qualify it after. Then they could just white out whatever you put at the end. Qualify your signature first, then sign. Let's proceed.
That we have.
Your Honor, there is no international.
And you should not be saying Your Honor. You can say My Honor, right? You can say My Honor because my honor is at stake. My honor is at stake here, or you can just simply call him by his name, or just speak. You don't say my Your Honor, because it's a way of giving them recognition in the sense that you see them as an authority. All right, let's proceed.
A contract that, we've asked the prosecutor to produce an international contract that would bind me to this statutory proceeding, and I'm not aware of any contract. In the absence of such contract, I motion that we dismiss this case.
I've already
Yes.
dismissed that motion.
Yes.
You can move to the circuit court and.
Okay, here's another thing. As an American national, as a person who's standing before the court, you don't appear, you stand before the court, because only a man or woman can stand. Corporation doesn't stand. It appears, aberrations appear, dead entities appear. If you're submitting documentation into a court case, do not put motion on your paperwork. Motion is part of that jurisdiction. He can, as he said, he dismissed it because it's a part of their jurisdiction, motions. People who are sovereign, people who are American nationals, who are natural men and women, we can make a edict. We can make a declaration. All right. You can also put in a writ. All right. You put in a writ, and with your writ, you're giving instructions, or you can put in a writ will be the best statement to use. Let us proceed.
You can appeal my decision as it relates to that. File a motion. I'm going to give you a date. I'm going to give you a date where that motion is going to have to be due. I will entertain that. I'll give the people a date on their response if they choose to respond.
I do not wish to continue or delay this any further. There's been no evidence presented to substantiate any kind of jurisdiction in this case. This is our second time. I've asked for this the first time, and there's been no evidence of any jurisdiction, and I don't understand why you're insisting on moving to another court date, and we have not addressed this very basic and fundamental issue of jurisdiction. Well, I mean, I don't understand why we are delaying this any further.
We don't have to delay it any further. I can put a warrant out for your arrest.
Under what grounds, under what basis are you putting a warrant out for my arrest? And you
I didn't say I was gonna put a warrant. I said if you're telling the court that you're not gonna come back to any court dates, then that's up to you.
I don't.
Just pay attention to the intimidation tactics. Remember, he's saying he can. He's not saying he will and things of that nature, okay? And later on, you'll hear him talking about he's going to set a date for trial and things of that nature. You're supposed to object to those things. That's all the stuff that he's saying right now. You just say objection. I object to that. You know, sir, you know, whatever his name is, ma'am, if it's a lady, you know what I'm saying? And you have to object to it. If you remain silent, then you're consenting. Okay. So you have to object.
I don't wish to delay this any further. There has been no proof of jurisdiction. There is no live injured party. I mean, there's a claim that the city of Detroit is an injured party, but I'm not aware of any international agreements or contracts that I've entered into with the city of Detroit. And
also, there was no grand jury indictment. All right, there was no grand jury indictment. So pay attention to that also, okay? Because that's part of your rights to due process.
the prosecutor can't provide that. And it seems like there's a bias going on here because flat on his face, the prosecutor hasn't even spoken on this issue. And you just insist that we move to another court date. And I don't understand. I mean, your oath of office is to uphold the Constitution.
What you're saying in essence, right? What you're saying in essence is that I don't have any authority.
I'm asking you to prove your authority.
That's a trap, people. When he says that you're saying that I don't have any authority, you're supposed to object to that. Object to that because, yes, he does have authority inside of his jurisdiction. That's not the jurisdiction that we're trying to go into. We're not trying to go into a military tribunal or a maritime jurisdiction or anything outside of the Constitution and or the common law. Okay, so these are trick words. So you just simply, he should be objecting to that. You know what I'm saying? Objection. I haven't made any statement to that effect. However, and you go back to your circle, which is this court operating under the common law jurisdiction or under the organic Constitution of the United States for America, not of the organic Constitution or the Constitution of the United States for America.
I'm asking you to prove your authority. I'm trying to understand where your authority is coming from. And you're failing to do so.
Read the Michigan court rules, read your statutes, read the Constitution over again, and you'll find that.
As I said before, I'm not asking you for legal advice or
and the Michigan Constitution.
You have, if you have a legitimate jurisdiction, I'm asking you, is it a criminal jurisdiction under statutory law, or is it under the common law?
We're gonna give them a trial.
And you will not answer that.
Okay, here's where it goes, people. Okay. The judge does not have jurisdiction, obviously. Everybody here, we all in agreement that he does not have jurisdiction, okay? The thing is, you have to object to the false or inappropriate jurisdiction, okay? That's what the CPLR states. You have to object to the incorrect jurisdiction and then state the correct jurisdiction. Okay, the judge can dance and squirm all he wants, as long as you articulate that the jurisdiction that has been brought before the court is an improper jurisdiction and venue, and you articulate what is the correct jurisdiction and venue. At this point, the judge is actually supposed to be shutting up, because now it's the obligation is on the prosecutor to articulate, because the prosecutor is the one that picked the jurisdiction and brought that case into the courtroom. So it's on the prosecutor to do that. This judge right now is actually operating ultra vires, which is outside of his authority. All right, because he's not supposed to be arguing this point with this guy. You know what I'm saying? He's supposed to be deferring it back to the person who brought the case, which is the prosecutor. But the judge and the prosecutor are in bed together, so he's protecting his buddy. All right. So let us continue.
That question.
Well, we'll give him a jury trial date.
Wow.
August 9th.
He's supposed to be objection. He's supposed to be objecting right now. He's supposed to be objecting. He doesn't have jurisdiction, so you can't push this thing forward to a jury trial or anything. Any kind of trial. You can't push it forward. You have to object. Why? Because if you remain silent, the judge said it. He said jury trial. So if you remain silent, you're granting authority. You're granting. So, wow is not a good answer. What he just said, wow, that's not a good answer. You have to object.
2022.
Your Honor, we cannot proceed until I understand the nature and cause of the action against me.
I'm going to say this one last time to you, sir. Go, and if you want to speak to the court, if you have any objection to the court and these set dates, and if you don't feel that these dates are lawful, and if you, whatever your claim is that you're stating, you speak to the court through motions, and I want that, and those motions that you're entertaining.
Speak to the court through motions. He keeps trying to get you to use motions because that's going to bring you into the jurisdiction. Pay attention.
On the record right now, I've dismissed some of them already. I want you to file those motions with the court.
Under no basis
so that the court can read your motion.
What he should do is throw a writ at him and a letter rogatory. Letter rogatory is where a man or a woman tells a public servant the instructions on what they want them to do. That's a letter rogatory. So you send them a letter rogatory and let them know, listen, this is how the case is going to go. You're going to prove jurisdiction. You're going to prove, whatever it is that you say that you have a right to be doing, or that, I'm saying that what you're doing is correct, and all, you got to prove all of that now. All right. And you give them those instructions in your letter rogatory. And you put if you're going to put in a quote unquote motion, put it in the form of a writ. Don't put the word motion on it. Okay. Do not put the word motion on it. You can put affidavit and you put writ. Do not put motion.
And make a ruling and give the city attorney an opportunity to respond. If you do it the proper way, you might learn something. Even if they show you documentation like it is in black and white, you're not going to believe that anyway.
I still have this same question that you keep failing to answer. And without that question being understood,
and that's it. I'm done talking about it, okay? That's it. So I'm going to set
let the record show that.
As it says on the screen, he needs to be objecting. And he also needs to tell the judge that the judge needs to recuse himself because he's practicing law from the bench. And he's operating ultra vires. He needs to step down and recuse himself. But the gentleman definitely needs to be objecting. This gentleman needs to be objecting.
The judge is refused.
Listen, sir, don't interrupt me again, okay? Don't interrupt me again. Let's set a motion there.
That's another thing. The judge, and I posted this inside of the Legal Crest on YouTube. I just posted the judicial disciplinary actions. All right, and this is one of the things that the judges get disciplinary actions on when they don't allow you to finish saying what you're saying. They don't allow you to articulate your point because the Constitution affords every man the right to be heard. So when he cuts you off, he's preventing you from your right to due process. All right, he's warring against the Constitution at this point. Let us proceed.
4.
I do not consent.
Please do not say anything else, sir. I know you said.
Sir, I'm exercising my Sixth Amendment right. The Sixth Amendment, exercise of an amendment right cannot be converted into a crime, sir.
I'll hold you in contempt of court, sir.
Now, I also mentioned in the disciplinary, when the post that I put on the Legal Crest, I posted in there the disciplinary actions that are made against the judges and stuff like that by the superior judges, the commission, the judicial commission. That right there, the judge right there holding him in contempt, there are steps that need to be taken in order for a judge to put an individual in contempt of court. Okay? The judge just violated again. Let us proceed.
As I stated before, I'm trying to understand the jurisdiction of the
I'm not
court.
going to deal with you. You're going.
Okay, another thing is also the judge. Okay, in order for the judge to hold somebody in contempt, first of all, contempt of court. Okay, that's a violation. That's a violation. Okay, the violation has to be articulated what the violation is, and the other thing is this: who's the injured party? If there's a contempt, who's the injured party? The judge. And I've actually had a judge say that he was the injured party, and all of a sudden, he wants me back inside the courtroom because he locked me up, but then all of a sudden he wanted me. I mean, not even an hour later, he brought me back into the courtroom. He wanted to find out what the situation was, where I was at. And I was like, listen, you know what you did. You know you violated. And you know what I'm saying? You violated all judicial code. And so, all of a sudden, he changed his whole program. But, in order for there to be a contempt of court, there must be an injury.
Pursuant to
I'm holding your client. Well, Mr. Berry, you are not representing this client because this client is probably. Do you want the representation of a lawyer, sir, at this point now, sir? Because now you're looking at 30 days in the Wayne County Jail. Do you want the representation or not?
Please let the record show that I have attempted to understand the jurisdiction of this court, and this court has refused me that answer. And apparently, it is a jurisdiction only understood to bar members and licensed attorneys. This is a direct violation of the Constitution, and I do not consent. I do not agree. Your Honor, I do not wish to be held in contempt.
It's too late.
Okay, what he said, I do not wish to be held in contempt, that's not what you should say. All you need to say is, forgive me. I ask for the court's forgiveness. All right? You have to ask for the court. You're appealing to the court, not to the judge. The judge is not the court. The judge keeps the order of the court. He's the referee in the court. He's the referee in the court. All right? And this is part of the reason why a judge is not supposed to be doing this back and forth with you. It's supposed to be you and your quote-unquote adversary, which is the prosecutor. All right? So what the judge is doing, everything this judge is doing is wrong. Everything he's doing is just all wrong. So what you should say in this case is, I ask for the court's forgiveness, or forgive me. 2 words. Forgive me, or I ask for the court's forgiveness. Let's continue.
I've merely asked a very basic, simple question, and you have refused to answer it. I feel as though the court is trying to constrain me to an unfair plea in absence of my understanding of the nature and cause of the action against me.
I'm going to order you to report to the Wayne County Jail.
Interruptions are not contempt of court. It's not a contempt of court, okay? And again, you have a right to be heard, and he's preventing you from being heard. So he's already overstepping the bounds. Let's continue.
Today,
I do not accept.
sir, please don't. I told you don't say. I'm going to add some more days if you keep on talking. You already got 30 days.
I don't understand, sir.
I'm adding more if you keep on talking. Please do not say anything else.
Now, by remaining silent, you're showing that he's an authority. All right? By remaining silent, you're showing that he's an authority. So what do you say in this respect? You object, you circle back to jurisdiction, and then you're supposed to ask the judge who's the injured party regarding this contempt. Let us proceed.
It says here, after the court determines whether criminal or civil contempt proceedings are appropriate, the court must determine whether the contempt was direct or indirect. If the contempt was committed during its sitting and in the immediate view and presence of the court, the contempt is direct, and the court may summarily make a finding of contempt and punish the contempt. So I'm determining that this is criminal intent, the contempt. I am determining.
Since when is interruption criminal? Hilarious, people. Please, just pay attention to what this nonsense. It's nonsense. Interruption is a criminal intent, people? Kangaroo courts, man. This is some bull crap. Okay, people, let's proceed. This guy needs to be snatched off the bench. Complaint to the risk management, complaint to the bar, complaint to the senior judge of that, whatever county that is, senior judge, and you send a letter, a writ to this judge, and a letter rogatory instructing him that he needs to step down. He needs to recuse himself from this case immediately. It's a conflict of interest. He's showing that he's not being he's violating Judicial Code 100.1, which is that he's supposed to be impartial, and he's being very, very partial. Okay, he's being very, very partial. He's leaning toward the prosecution because he's supposed to have dismissed the case off the rip, just off of the jurisdiction issue alone. He's supposed to dismiss the case. Let us proceed.
Determining that it was done during the sitting of the court. On the record now, I've asked the young man, Mr. Jamil Lockhart, or as he has on here, Jamil of the family Lockhart, to continually not interrupt. The court is trying to set dates so that Mr. Lockhart's motions, if he wants to, or any of his pleadings can be preserved in writing.